All right, good afternoon and welcome to the Tenants' Rights under the RLTO and Post-COVID Evictions webinar training for case managers. My name is Melanie Felt. I have been with All Chicago since 2018. My role here is a rapid rehousing housing locator, which is a rental assistance program if you're not familiar with rapid rehousing. I have worked in subsidized housing for the past 5 years. I co-lead the system-wide Landlord Engagement Workgroup, also known as SLEW, and I also help to conduct trainings on tenant and landlord rights and responsibilities. Soon, I will be helping to mitigate issues with landlords to avoid filing evictions. And we do have Camilla Cross with us as well, who will introduce herself from Legal Aid Chicago.
Hi everyone, my name is Camilla. I'm a staff attorney at Legal Aid Chicago. I've been there for about 2 years. For anybody who doesn't know, Legal Aid Chicago is the largest provider of free civil legal services in the Midwest. We specialize in Chicago and Cook County. The housing practice group specializes in subsidized housing, and we also assist tenants who are living with HIV or who are survivors of domestic violence. And Melanie, if you want to get the presentation started, I can start talking about the CARES Act and evictions after COVID-19. Okay, so we do have some handouts. They're in both English and Spanish that have been distributed about the general eviction process, and they are being periodically updated, so make sure to check out Legal Aid Chicago's website for the most recent information. Okay, next slide. All right, so on May 29th, the governor issued an executive order which prohibits landlords from commencing any real estate or residential eviction action unless the tenant poses a direct threat to the health and safety of other tenants or poses an immediate and severe risk to the property or causes a violation of a building code, health code, or a similar ordinance. The governor is expected to extend that executive order in the next couple days. That has not happened yet, but he has issued his intent to do that. So we believe that that order will be extended through the end of July. Next slide. So like I said, landlords cannot file eviction cases except in very limited circumstances. However, they may still be able to issue notices. They will likely not be able to file the cases. Next slide. If a tenant learns that an eviction was filed against them between April 23rd and June 27th, they should contact legal aid immediately. In this case, because there will be an extension on that, instead of June 27th, it will likely be through July 31st. However, there hasn't been an official announcement of that extension just yet. Next slide. If a tenant already has an eviction case pending in court, there are tools that they can use to look up their cases, and they can also call the clerk's office to find out when the next court date is. Because the court closures are so up in the air right now, tenants who have active eviction cases should be proactive about making sure that they know when their next court dates are so that they don't miss any important dates. Next slide. If you think that your landlord has filed a case against you, you can look online. The website is provided there. If you have tenants that have names that are a little bit tricky, it's a good idea to check different spelling variations because you have to spell it exactly right in order for it to show up. Generally, landlords have to file the case with a last name and then first name, but sometimes they do it in reverse, so it's good to check a lot of different options to make sure that a case has not been filed against the tenant. Next slide. This is really important right now. With evictions, the sheriff is the only person that can actually enforce the eviction. So even if a landlord currently has an eviction order against a tenant, the landlord cannot self-help and cannot lock the tenant out. Only the sheriff can remove the tenants and the tenant's property from the unit. And right now, sheriffs are not enforcing eviction orders until at least July 6th, but again, we anticipate that that will be extended at least until August 1st. Next slide, next one after that. On March 26th, the Federal CARES Act, which is the Coronavirus Aid, Relief, and Economic Security Act, went into effect. Next slide. The CARES Act covers tenants who are in properties that participate in a federal housing program or that have federally backed mortgages. Next slide. Federally subsidized tenancies, so public housing, housing choice vouchers, HUD housing, which is generally project-based Section 8 buildings, most supportive housing, low-income housing tax credit are all considered covered properties. And other properties that are covered are those that have a mortgage that was bought by Fannie Mae or Freddie Mac, or otherwise made, insured, guaranteed, supplemented, or assisted by a federal agency or official. If a landlord has a mortgage, it's very likely that it is covered, but the best way to figure out is just to ask the landlord. Next slide. If a property is covered by the CARES Act, the landlord is prohibited until July 26th from giving tenants notices to vacate or filing eviction cases for non-payment of rent. In Illinois and in Chicago specifically, because of the extension that we anticipate from the governor, they won't be able to file anything for, until at the latest, or at the earliest, excuse me, August 1st. But this is a little bit more protective because in this case, they can't even issue notices. There is a little bit of a gray area about whether this is specific to non-payment or whether it includes all evictions. And unfortunately, this issue has not been litigated yet. So we know it definitely covers non-payment, and whether it covers other types of evictions is to be determined. After July 26th, a landlord in a covered property has to give the tenant at least a 30 days notice before filing an eviction case. So where you normally might see like a 5 or a 14-day notice, it will have to be a 30-day notice if the tenant is in a covered property. Next slide. So how to figure out if it is a covered property. So first place to start is to ask the landlord, and you can ask if they have a mortgage. If they do, there's a good chance that it's federally backed. And there are also lookup tools that are linked at the bottom there that you can use to check. In Cook County, you can also search for like the Recorder of Deeds website to see if the mortgage is listed there. And it's always good to check multiple sources because sometimes not everything is listed, not everything appears when searching on these sites. Next slide. Okay, due to the emergency, the circuit court has rescheduled all existing eviction court dates until after July 6th. As of today, which is June 26th, a new order was actually entered by Judge Evans, which extends and reschedules all eviction court dates until after July 31st, 2020. What the sheriff is going to do is to be determined, but we do not believe that they will be enforcing eviction actions prior to August 1st, 2020. Next slide. Okay, so if an eviction case is filed against a tenant before the executive order, so if it's currently pending in the court, as of yesterday, it would not have moved forward until July 6th, but as of today, it now will not move forward until August 1st at the earliest. So it's important to note that date change. It's now August 1st. And if an eviction order was entered against a tenant before the court suspended its normal operations, it's likely and probable that the sheriff will not come out until also August 1st at the earliest. Next slide. Okay, this is a really important point. Tenants are not excused from paying rent at this time. There are no laws that forgive rent. The moratoriums and executive orders delay the eviction cases, but landlords are not required to forgive any unpaid rent, and tenants will eventually have to pay any unpaid rent that accrues during this time. And unless the property is covered by the CARES Act, the landlord can still give a 5-day notice and can file the case after, instead of June 27th, that's now been extended to August 1st. Or we anticipate that that will be extended to August 1st. Next slide.
All right, so we did conduct a poll and I've included those responses here. The poll question was if free mediation services We're available to case managers to help mitigate issues with continuum of care landlords to avoid filing evictions. Would your organization take advantage of this service? So out of 82 attendees on our webinar, we got 57 responses. 89.47% responded yes, and 10.53% responded with no.
So this is a good time to mention a new ordinance that also passed this week. It applies to all rental units in the city of Chicago, except for some non-traditional units like hotels, college dorms, and co-ops. It is a little bit more expansive than the RLTO, which Melanie will talk about in a few minutes. But this new ordinance says it prevents landlords from filing evictions for past due rent when the tenant's ability to pay has been impacted directly by the COVID-19 pandemic until the landlord and tenant have made a reasonable attempts to work out a payment arrangement. So what this means is that once a landlord gives the tenant the notice of non-payment requiring them to pay, if the tenant then has 5 days to tell the landlord in writing that their income has been impacted because of the pandemic. It's really important that if a tenant is going to report that their income was impacted, that they do so in writing. It can be a text, an email, a letter, whatever it is, it has to be in writing, and it has to be within 5 days of the date of the notice. Once a tenant has stated that their income was impacted by the pandemic, then the landlord and the tenant have about 7 days, I believe, to negotiate some type of reasonable arrangement. So they might enter into some kind of repayment agreement, something like that. That's a time when mediation might be really helpful to take advantage of. It is important also to make sure that you're advising tenants to do this, because if a tenant says that their income has been impacted by the pandemic and they report that in writing to the landlord within the correct time frame, and the landlord does not engage in these discussions, that could be a defense to the eviction. And it is also important that tenants should contact an attorney or some kind of legal aid services if they are having difficulties paying rent or know that they owe money. They should not wait until an eviction is already filed. So if you have any tenants that have rental balances that are accruing, I would encourage all of them to apply for financial assistance now. Next slide. Okay, so as we've discussed previously, the moratoriums will delay the eviction process substantially, and everything is evolving as we've seen today. One of the orders came out as we speak. So it is really important to make sure that you're staying up to date, and this can also mean that tenants have some leverage when they're negotiating with landlords. If they're trying to negotiate a move out or something like that, they may have a little bit more leverage than they generally do because the court system and the sheriffs are so backed up. Next slide. Okay, if a tenant has any kind of housing subsidy, they should ask their housing provider or subsidy administrator to conduct an interim recertification if they've lost income, so that it will adjust their rent accordingly. Not every single housing subsidy requires that the rent portion be determined by the tenant's income, but if you have a tenant that has a subsidy, you should always encourage them to report the income just in case their subsidy does fluctuate with their income. Okay, next slide. The interim recertifications can be kind of tricky, especially now when a lot of the property management offices are actually closed. So if you have a tenant that needs an interim recertification and can't get one, you should contact legal aid because we may be able to assist with that. We have seen a lot of offices that are physically closed, and so when a tenant goes in to try to report a change in income, they can't get a hold of anybody. And then the management office says, okay, well, you didn't report your income, so we don't have any obligation to change it. So we want to make sure that we're doing this as soon as possible so that any kind of recertifications take place immediately. Next slide. And emergency rental assistance is really important. Right now, there are a lot of different funds that are popping up every day because of the pandemic, so it's important to stay on top of those. The best place to start in Chicago is generally by calling 311 and requesting some kind of homeless prevention or assistance funds. And Again, I would encourage any tenant that's behind in rent to do this as soon as possible. Next slide. If the tenant is currently going through the eviction process, LCBH, which is the Lawyers Committee for Better Housing, does have a court-based emergency rental assistance program, and the phone number is at the bottom of the screen there. So if any tenants are currently in evictions and have a balance, I would encourage them to call that number. Next slide. And yes, we've already mentioned 311, but it is a really good service because they can also connect tenants to different community service centers. And now I will pass it off to Melanie for the RLTO.
All right, thank you. So I will begin with the first slide regarding the Chicago Residential Landlord and Tenant Ordinance, also referred to as the RLTO. So what is the RLTO? It is a comprehensive ordinance in Chicago that basically governs the rights and responsibilities of tenants and landlords. It covers the rights to repair, retaliation protections, as well as rights to organize and more. The RLTO and the Chicago Building Code still apply during the COVID-19 pandemic. So who is covered by the RLTO? All tenants, including Section 8 and HUD, with the following exceptions. If the building is 6 units or less and is owner occupied, if the building is a hotel, motel, or SRO, or a place where tenants pay rent on less than a monthly basis, so perhaps a weekly basis, that would not be covered. And condominiums and co-ops, unless they're being rented out. But it does not cover employees who work, such as janitors and managers, in buildings in exchange for the rent. So some managers and janitors do receive free apartments for providing building services. So those employees would not be covered under the RLTO. And lastly, if you're not covered by the RLTO, you do still have rights. All buildings must comply with the Chicago Building Code and the RLTO's prohibition on lockouts and other interruptions of tenancy apply to all Chicago residents. And this is basically just a visual of buildings that are covered by the RLTO. Like I said previously, a unit where the landlord resides, a building where the landlord resides would not be covered if there are 6 units or less. However, if there were 7 units and the landlord stayed in that building is definitely covered by the RLTO. So in communicating with the landlord, it's very important to keep communications, copies of those, and to make sure that they're in writing. Please keep copies of all communications, either emails, letters, and texts, and try to document all repair and maintenance requests. Even if you have to make a cash payment for rent or whatever, get a receipt for that because it'll be important if you ever need to refer to a payment that you made for something and you have no proof of it. So I would strongly encourage you to demand receipts or possibly send a money order or a check or send money electronically so you would have some sort of receipt for the money that was exchanged. And if you or the landlord are negotiating for a reduced rent or rent deferment because of the virus, get that agreement in writing with a letter or in an email. All right, so rental agreements typically apply to both RLTO and non-RLTO. Again, I would, encourage having a written lease, typically of a year duration. Landlords in the situation of a lease have to supply a summary of the Chicago ordinance, the RLTO that we're discussing. They also must supply their address and phone number. Owners also have to apply lead disclosure forms for the building and the unit, for the unit. And then any building code violations that that owner has had for the past year should also be provided. There are times when there are month-to-month agreements, but basically each party would have to give 30-day notice if either chooses to terminate the agreement to a lease agreement. So after the year duration, typically a lease goes to month, but if the landlord or the tenant wishes to terminate that tenancy after a year, again, you must provide a 30-day notice. And again, during the COVID-19, we do encourage tenants to get written rental agreements. All right, so for maintaining your apartment, the RLTO and non-RLTO landlords are all responsible for maintaining the building by the standards set forth in Chicago's building code. Landlords are responsible for normal wear and tear and maintaining common areas. Repairs and upgrades promised in the lease should be written into the lease. So for example, if you're moving into an apartment and you do your final walkthrough before moving in, getting your keys, I would strongly suggest adding any things you notice that are in need of repair prior to moving in. That way that it's documented that you requested certain repairs or upgrades to be done for that apartment. All right, so what if the landlord fails to make a repair and you've been there several months, for example? One way you could go about getting the repairs done if the landlord is not responsive is by writing a letter and keeping a copy of that letter. Generally, you would send it to the landlord or the property manager via certified mail, and then wait 14 days after receipt by the landlord. When you send a letter via certified mail, you do have a receipt of when the letter is actually delivered, and it's you have like a receipt that you sent it and that it was delivered. So definitely hold on to that. If you must, still go ahead and do your own repairs after 14 days and the landlord still hasn't done anything, you can hire a professional repair person or purchase the components to repair the issue. One thing we would suggest again is keeping all receipts, and you can actually deduct the cost of any repairs from your rent, but I would definitely provide a copy of that receipt to the landlord and keep the original should an issue arise later as to why the rent was reduced. I wouldn't suggest deducting rent greater than $500 or half of the rent, but definitely if you have a receipt that would substantiate why you reduced your rent and for what reason. Section 8 and HUD tenants cannot repair and deduct, but they should still demand repairs in writing and report issues to their subsidy provider. So what if the landlord fails to make repairs? So you can do rent reduction as well, which applies under the RLTO. Again, it involves a lot of communicating via writing and keeping copies of letters. You would wait 14 days after the receipt of the delivery of that letter, and only after that point, if the repairs have not been done, should you consider trying to reduce the rent. But the reduced rent should only reflect the reduced value of the unit, but always do pay some rent, because if too much rent is taken off, it could result in an eviction. A judge could determine that the amount withheld was not reasonable. So try to keep that deduction at 20% of the rent or less. So what if the landlord fails to make repairs? So this guidance provided by the Metropolitan Tenants Organization is to terminate tenancy. This is yet another option that you could, take if your repair requests have gone unanswered. You can write a letter, keep a copy of that, wait the 14 days once again, and if the landlord has not responded to your request by making the repairs or responding to you, you can definitely send a follow-up letter terminating your lease. After the 14 days pass, the tenant should move out in 30 days. So be prepared to move out within 30 days if you choose to go this route. One caveat to this is that Section 8 and HUD tenants cannot terminate their lease without first reporting this to their subsidy provider. So, and again, keep in mind that for the failure to make repairs, like the unit must be so uninhabitable and not fit to live in that you would choose this option. So it should, it should be that the lack of repair is just so, terrible that all these problems or code violations are just making the unit unfit and uninhabitable. So that would be the only reason to really terminate your tenancy in this way. And so basically the RLTO does provide minimum guidelines for temperatures in buildings as well. Yes, we're in the midst of summer, so a lot of us are not having heating issues at this time. However, from September 15th through June 1st, the minimum temperatures during the day hours is 68 degrees, and at night, the minimum building temperature is 66 degrees. So if the Chicago Building Code and the RLTO, they do make special provisions for the lack of heat, insufficient heat, water, electricity, or major plumbing problems. And if you suspect there is a dangerous situation, definitely contact the Department of Human Services, and we have provided the number here. The MTO has also updated a list of available shelters and warming centers should that be a need for you during the winter months. We also have provided some additional resources should you need to contact them on this page for the Illinois Commerce Commission. What else? ComEd, People's Gas, and the Chicago Department of Water. We have included both their phone number as well as their website. But in general, the Illinois Commerce Commission has ordered a moratorium on utility disconnections and the assessment of late fees through May 1st of 2020, or until the governor announces an end to the COVID-19 emergency. So tenant remedies for heat and essential service problems. Once again, call 311, request an inspection. Keep in mind that stoves should not be used as a source of heat, as that's very dangerous. If the landlord has not paid a utility bill, RLTO tenants can call the utility company and pay the debt owed. And they can also deduct that from their rent as long as they provide 24-hour notice. RLTO tenants can reduce the rent or repair and deduct by buying a space heater, for example, with a 24-hour notice. And non-RLTO tenants should call their alderman and 311 for building code enforcement. If the tenant wants to terminate their lease, they must send a 72-hour notice. All right, so tenants do have rights to privacy. A landlord should always provide you with 2 days notice if they would like to enter your unit, except in an emergency where perhaps, the unit above yours is flooding and water is running into your unit. They would have the right to enter your apartment without that 2-day notice in that sort of a situation. Entry generally is allowed during business hours or 8 a.m. to 8 p.m. unless there's some other agreement. And due to the virus and the governor's stay-at-home order, landlords should not visit tenants at this time unless essential repairs are needed. It's not yet clear how the COVID-19 emergency impacts the landlord's right of entry. However, if you do believe the landlord's entry is not necessary and it endangers your health, you can notify the landlord in writing about why you believe the entry is unreasonable, and you should contact the MTO or Lawyers Committee for Better Housing for further assistance. I'll briefly cover the Safe Homes Act and the Violence Against Women Act because originally we, were not going to include this, but the governor's stay-at-home order does not prohibit victims of domestic violence from leaving their homes to stay at a safe alternate location. The Violence Against Women's Act does apply to public housing residents, and it protects victims of domestic or sexual violence, stalking and dating violence, as well as immediate family or household members. Actual or threatened domestic or sexual violence, stalking and dating violence does not give landlords the right to evict someone if the victim is a tenant or immediate family member of the tenant. So landlords cannot use an applicant's history as a victim under VAWA as a reason to refuse to rent to them. All right, so next we'll be covering lockouts. These are all examples of lockouts. So basically, if you experience any one of the examples of lockouts, step one would be to call the police because they must be present at the premises. Step two, like if a landlord refuses the police request to provide access, ask the officer to arrest the landlord for failing to end the lockout. A lockout is definitely, well, from what I'm understanding, it's occurring more often these days where landlords are choosing to self-help and maybe shutting off utilities, preventing the tenant from being able to use different, resources such as electric or water. So that is also considered a lockout. So if an officer is not helpful, you could ask for a beat sergeant or other person to enforce the special police order. And just basically follow the steps on this slide should you experience a form of lockout at your building. Here's some more information about lockouts. There's an actual link to that on the LCBH website, as well as on the Chicago Police Department website. And it's Special Order SO4-01-03. So the form of lockout referred to in this slide is regarding utility shutoff and harassment. Intentional utility shutoff by a landlord is a lockout, and tenants can contact the local police department in Chicago and refer to the CPD special order for assistance with that. Other forms of harassment, such as improper entry or repeated unnecessary entry, can also be addressed in this manner. And renter remedies. So the right to file an emergency petition with the court, although it's not ideal at this time because of all the delays and things that were discussed earlier in the presentation are going on. This does require an appearance in court. And because of the moratorium, a lot of cases have been postponed or delayed. So the reduced court staff may also slow the process. Contacting your police department is probably the number one thing for right now, in addition to your local legal aid for help with notifying the landlord about unlawful actions and demanding access or restoration of services. And retaliation will be one of the final things we discuss today. If you live in an RLTO building, it is unlawful for your landlord to retaliate against you because you complained about bad conditions or unlawful landlord practices to the city. So you should contact your landlord, your city, your alderman, any governmental agency or community agency to assist. But it is unlawful to retaliate against a tenant because they exercise their right or legal remedy under any applicable law. So some of the behavior that is prohibited and considered retaliatory includes terminating your tenancy, increasing your rent, decreasing your services, threatening to evict you, actually filing an eviction against you, or refusing to renew your lease. So if you believe your landlord is retaliating against you because you complain or attempted to exercise your rights, you should definitely contact the Metropolitan Tenants Organization, the Lawyers Committee for Better Housing, or another local legal aid organization for assistance. And I did include the MTO hotline as a resource as one of our handouts as well. All right, lastly, our co-presenter Camilla Cross does work for Legal Aid Chicago. So this slide is basically providing information on how to reach legal aid, and I'll let her take it from here.
Thanks, Melanie. So our services, as I mentioned at the beginning, are free to those who qualify based on their income. It's generally very low income tenants that qualify for our services. The best way to reach us is by calling, advising tenants to call early in the morning. That's when our intake lines are generally open. The housing practice group does subsidize or specialize in subsidized housing, and there are some limited exceptions for tenants that are living with HIV or survivors of domestic violence. So if you have any tenants that are having housing issues that live in subsidized properties or are survivors of domestic violence or living with HIV, please feel free to refer them directly to me, and my email is at the beginning of the presentation. I did also want to make one quick correction to something I stated earlier. The order that came out today from Judge Evans does say that no eviction actions can commence until after July 31st of this year, and it also says that the sheriff will not be enforcing orders until after July 31st. However, the order itself is silent as to what is going to happen with pending eviction cases, whether or not they will be heard. The press release that was issued does make it sound like all of those cases will be continued, but if any of your tenants have currently pending eviction cases, make sure that they are checking the docket and calling the clerk to find out whether those court dates will be rescheduled or not. And Melanie, I will hand it back to you.
All right, thank you very much. So there's just one other option. So be sure to have your documents available if you choose to call in to get assistance from legal aid, or we've also included Camilla's email address at the very beginning of the slide. So that might be a way to kind of bypass the intake process over the phone if you email her directly. So lastly, this is another slide from Legal Aid, like a snapshot of their website. If you choose to apply for services online, this is directing you where to go. And we want to thank you for joining us today. If you have any suggestions or comments for other webinars regarding housing that you would like to hear about, don't hesitate to contact our training department, and we would be happy to facilitate that for you. Thank you so much for being with us today, and enjoy the rest of your day. Okay, I stopped it. I was like, wait a minute, does it stop? Whew. Camilla, are you there? Oh, she hung up. Yay. It is over. I did it this time. Thank you, God. There was no craziness. Oh, thank you, God. It's perfect.